On behalf of the University of Wisconsin Latino and Black Law Student Associations, welcome to Understanding Police Use of Deadly Force. When a police action results in the loss of life, this concerns us all. In this video, we will discuss police training, the law, and the process of how officer-involved deaths are investigated. When it comes to using deadly force, the standard is really simple and also really complex and fact-specific. In Wisconsin, we have statewide training standards that are used to train all police officers that are certified in our state. These standards, along with our laws and our courts, tell officers how to conduct themselves. So, when can an officer use deadly force? An officer can use deadly force in order to stop the threat. And by threat, we mean a person posing a threat of death or great bodily harm. The officer must stop using deadly force once that threat is stopped, and the officer must use the least amount of force necessary in order to stop the threat and resolve the situation. It's important to remember that in many cases, the officer is making this decision in a very short amount of time under a great deal of stress. The officer must have a reasonable belief that he or she or a bystander is at risk of dying or being very seriously injured. To test how reasonable this belief was, we must ask ourselves, would a reasonable officer have acted the same way in the same situation? So what is deadly force? Deadly force is a police action that is likely to cause death when used against a person. Deadly force obviously includes the use of an officer's gun, but it can also include use of other weapons depending on how they're used and for how long. The same is true for how an officer perceives a threat. A person can pose a threat by using a gun or another weapon depending on how it's used. This can include hands, feet, and fists depending on the situation. Remember that most officers use force in order to protect themselves and others. If you have a police encounter, try to stay calm, do not resist, and do not ignore police commands.
Questions about the investigation of officer-involved deaths, that is, the death of a citizen at the hands of the police or in police custody, have long been the subject of controversy. In 2014, the Wisconsin legislature enacted 2013 Wisconsin Act 348 to create uniform statewide procedures in this arena. This new law applies to any investigation of incidents happening after April of last year. To best understand the new procedures, it may be helpful to look at some of the issues involved. Transparency. Public confidence in any investigation requires that it be understandable, open, and accessible to the public. A frequent criticism is that prior investigations were held in secret and also with no public knowledge of the facts. Impartiality. Public confidence also requires an impartial decision maker, one whose position does not suggest that he or she would favor one conclusion over another. This has been a problem when police investigate members of their own department and when district attorneys investigate members of a police department that they work with on a daily basis. Competence. The competent investigation of a death requires expertise and training. It is important that whoever is responsible for the investigation is trained, available to immediately secure the scene, and manage all parts of the investigation.
The three concerns that should be considered when digesting this new Wisconsin law, which are transparency, impartiality, and competence. I'm going to discuss those and how the new Wisconsin law addresses each of those concerns. Regarding the first concern, which is transparency, it's been argued that secrecy ensures the efficiency of these investigations. It has also been argued that secrecy weakens the public's confidence in these investigations and also gives them serious doubt as to the final result. Now, according to the new law, which addresses both of these concerns, initially, the investigation will be held confidential. But if it is determined that charges will not be filed, then the public is granted access to this investigative report. So the law has taken steps to address both concerns, keeping the investigation as efficient as possible and allowing the public to analyze these reports if it is determined that charges will not be filed. The new law also requires that police agencies make their policies governing these investigations available to the public. The second concern is impartiality. The new law requires that the investigators be outside of the agency involved. For example, the Madison Police Department. If the officer is a Madison police officer, the persons investigating the actions cannot be a part of the Madison Police Department. They have to be from another outside, unrelated police agency. This reinforces the concern of impartiality. It minimizes any effect of bias or favorable attitude toward the police officer because these persons investigating are not familiar with the police officer, have no personal relationship with the police officer. So it ensures a high level of objectivity when conducting these investigations. The third concern is competence. Now, the law does not require that the investigators have any specific level of competence or training. But in practice, what similar agencies have done in adhering to the similar laws is that they're placing experienced homicide detectives on these investigative teams. So while the law does not require that the investigators have a specific level of training, the investigation teams in practice all have experience in investigations such as homicides.
What is a prosecutor? A prosecutor is a district attorney and an elected official in our county responsible for making the decision of whether or not to charge a crime. A crime may be charged if it is found that there is probable cause. This means that there is a reasonable likelihood that this crime occurred. But the district attorney may decide not to charge this crime unless they find the evidence suggests that the person is guilty beyond a reasonable doubt. Under our system of laws, the choice of whether or not to charge lies solely with the district attorney. Homicide is a crime where the harm caused is the death of another person. The Wisconsin legislature defines this in 3 different categories: intentional homicide, reckless homicide, and negligent homicide. Intentional homicide occurs when there is intent to kill another person. Reckless homicide occurs when the person engages in behavior that creates a substantial and unreasonable risk of great bodily harm or death. Negligent homicide occurs when the person uses a dangerous instrument such as a gun, a bomb, a car, or even a vicious animal. And although this person doesn't intend to cause harm to the other person, they should have known that the behavior they were engaging in created a risk of death or great bodily harm. When deciding whether or not to charge a crime, the prosecutor must decide what particular charge they will bring that best fits the facts of the case. Next, the prosecutor must decide whether the evidence shows and meets the legal elements of the crime charged. If the prosecutor does not believe that he can prove these elements at trial beyond a reasonable doubt, he or she will usually decide not to charge. Next, we will be discussing defenses. Just as the Wisconsin legislature decides what constitutes a crime, they also define when a person is exempted from prosecution for behavior that would be otherwise deemed criminal.
In Wisconsin, there are 3 defenses that may be offered to police officers. The first of which, self-defense or defense of others, may apply not only to officers, but to everyone. In order for this defense to exist, three things must happen. The first of which is that the person must be in danger of death or great bodily harm, and that danger must be about to happen. The second thing is that the person reasonably believes that force is necessary in order to stop that threat. The third thing is that the amount of force used must be necessary. The second defense applies to public officials generally. Underneath this defense, a person is not guilty of a crime if their actions are a reasonable and authorized fulfillment of their duties. The third defense applies solely to police officers. Underneath this defense, a police officer may engage in conduct that would otherwise be considered a crime if it is a reasonable accomplishment of their arrest. It is important to note that not all three defenses apply in every scenario. Sometimes all three may apply, and other times, based on the facts, only one or two may. So a term we've talked about a lot has been reasonableness. It's important to note that reasonableness is not viewed from the perspective of the juror or the prosecutor, but of the person who is in the situation at the specific time. Let's talk a little bit more about reasonableness.
An officer's use of deadly force against a suspect is legally defined as a seizure. An officer may use force when detaining a suspect. But when is it legal to use deadly force? In a case called Tennessee versus Garner, the Supreme Court of the United States said that an officer may not use deadly force unless an officer reasonably believes that a suspect poses a significant threat of death or serious physical injury to the officer or others. When determining whether the officer's actions were reasonable, the court considers three things. 1, the crime being committed. 2, whether the suspect posed an immediate threat to the safety of the officer or others. And 3, whether the suspect resisted arrest or attempted to escape. Although the legal standard for the use of force is well established, each case is unique. When deciding whether excessive force was used, the courts consider all the facts known to the police officer at the time the lethal force was used. Of course, these facts differ with each case. In looking at all of the circumstances that bear on an officer's use of force, the courts may consider the officer's training and the police department's policies. When deciding whether an officer's actions are reasonable, the courts try to avoid using hindsight and instead try to consider an officer's actions from the perspective of an objective police officer on the scene. The Supreme Court has emphasized that determinations of reasonableness must acknowledge that officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. Because civil rights violations are not criminal, when a court finds that an officer has used excessive force, the courts do not imprison the officer or impose a criminal penalty. Instead, when a suspect's Fourth Amendment rights have been violated, a court ordinarily awards monetary damages. When there is concern that violations of the Fourth Amendment have become routine practice at a police agency may also be subject to suit. When an agency is found to have routinely violated the Fourth Amendment through its policies and practices, a court can order a change to those policies and practices.
It is our hope that this video has given you a better understanding of the legal framework surrounding police use of deadly force. Thank you for watching.